Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Christina Ma, and today's episode is Biologically Similar, but Competitively Not So? Economic Considerations of IP Litigation Settlements Involving Biosimilars. Settlements between branded and generic pharmaceutical companies have come a long way since the Supreme Court's 2013 Actavis decision, in which the Supreme Court concluded that reverse settlement should be analyzed under the rule of reason and that large payments by branded drug makers to potential generic entrants to settle patent disputes could be anti-competitive. In this episode of our Curious Amalgam, we'll explore some of the complexities of pharmaceutical settlements today, and in particular, the unique challenges posed by biologic and biosimilar patent litigation and related settlements. Joining me today is my co-host, Anora Wang. Hey, Anora.
Hi, Christina.
So who are our guests today?
Well, we have two wonderful guests, Sheridan and Archan Ruparel. They're both principals at the economic consulting firm Charles River Associates. We would like to learn from them because they're economists and experienced expert witnesses. Sean and Archan have both worked on a great number of pharmaceutical and life science cases, and each brings to the table some of their respective expertises in antitrust and IP litigation. Sean has expertise in IP litigation as he has developed numerous damages analyses related to patent infringement, breach of contract, and trade secret misappropriation. Very, very wonderful expert on IP litigation. And then Archan has focused more on antitrust side of things, as well as IP litigation and commercial disputes. He has also advised pharmaceutical manufacturers, pharmacy benefits managers, insurers, and regulators. Again, wonderful experience, and we're very happy to have both of them.
Sean and Archan, welcome to the show.
Thanks. Happy to be here.
So as Christina already previewed, today's topic is a little bit a follow-up, I guess, from the Supreme Court cases on Actavis, which very much involves generics, which in very layman's terms, I guess, generics is a term used in describing small molecule, chemically synthesized drugs that contain the same chemical substance as a reference chemical drug that was originally protected by patents. And biosimilars refers to larger molecule, not exactly the same, but highly similar version of an already approved reference biologic product that has no clinically meaningful differences in safety, purity, and potency with the reference product. So that's a layman's understanding of what generics and biosimilars are. But I think what really piques our interest is that common to both, that the newcomer manufacturers, whoever manufactures the generics or the biosimilars, are likely to get into IP disputes with the original branded drug makers. And that's where I think we should start the conversation. So in those cases where a newcomer, whoever manufactures the generic or biosimilar version, which references original branded product, and then they have IP dispute, and then parties are looking for settlement. And then that's where you guys are really coming very helpful as economists. What kind of analysis are you usually asked to perform for a patent litigation seeking settlement? Let's start with Sean. How about that?
Sure. So the type of analysis we're typically asked to do in the settlement context is to look at the potential financial impacts on both parties, both the plaintiff and the defendant, under certain scenarios. Very broadly, it could be win or losing the litigation, but really, what's oftentimes of more interest, it's under certain potential settlement outcomes. The key in many of these analyses is an assumed date of entry. So when would the generic or when would the biosimilar product enter the market? Because once that happens, you're introducing competition that's going to have a pretty substantial impact on the branded product, and that's where the opportunity is to earn profits for the generic. So we're really modeling the economic implications for both parties under a number of different assumed outcomes.
I might jump in here
sure.
and suggest that there can also be some of the more strategic questions here. So what they might ask an economist, hey, how would we think about this if the branded manufacturer has a follow-on product? And this could be an issue where follow-on product might mean that the branded manufacturer can keep its sales force busy, which is really expensive, if that generic entry doesn't occur too early. But it could also imply that suddenly the market, the available sales of that original product for the branded manufacturer, but also for that generic, would shrink and go to that follow-on product.
So how do you think about impacts should the generic enter at risk? Is that a term of art?
Yes, and an at-risk launch, absolutely. And what that refers to really is just the generic or a biosimilar entering the market before they've before the patent litigation has ended, whether that's Hatch-Waxman litigation or BPCIA litigation. But in both cases, either the generic or the biosimilar needs to have FDA approval in order to launch. But when we think about what the impacts are, there is it's really a lot of what we were just talking about before. What's the financial impact on both the brand and the generic or biosimilar? And then, of course, when we're thinking about an at-risk launch, it's really what's the potential damages exposure for the generic or the biosimilar as well.
Let's drop a note here about the statutory framework that we just talked about. You referenced the Hatch-Waxman and which applies to generics, and then biosimilar is regulated by a different statute. Is that right?
Yes, that's correct. So Hatch-Waxman applies to small molecule drugs for large protein-based molecules. You have a different framework, and that's BPCIA. And I don't recall what the acronym is. Archan may have that at the tip of his tongue, but it's a different regulatory framework.
The Biologics Price Competition and Innovation Act.
Thank you.
Part of the ACA.
Yeah. Good to know. And then there are also, I guess, when we're talking about a settlement, obviously there are also considerations of the risk of actually losing or winning litigation if, the settlement didn't go forward. So how do you actually translate that into economic analysis? I guess in patent litigation, a lot of that would depend on a patent strength. Is that right?
Yeah, absolutely. And this is really one of the most critical aspects of the sort of financial modeling that I'm describing here. It's you can have what's called an expected value, so you can assume certain outcomes from the litigation, but then of course you have to assign probabilities to each of those outcomes. And you can refer to, and sometimes we do work based on statistics that are publicly available. Mm-hmm. There's a variety of sources out there that have patent litigation statistics, whether you're talking about district court litigation, appeals outcomes, or even IPRs, which is sort of another important consideration when you're looking at patent litigation risk. But these are just general averages of outcomes. And really, when you're working with a client, you want to talk to, as the economist, you want to talk to counsel and get a clear picture because they're going to know the strengths and weaknesses of the case, the strengths and weaknesses of the patents at issue. And so, it might not, in fact, it oftentimes is not appropriate to just use just general statistics and instead to really dig deeper and come up with probabilities that reflect the parties' beliefs.
Right. Let's come back to the Actavis framework a little bit, which is where we focus on the anti-competitiveness of things, and whether that can be evaluated, I guess, under the rule of reason. So Archan, perhaps you can take a lead in answering that. If, as economist, how have you been asked to evaluate a settlement for whether it's anti-competitive after fact or not, and how do you approach it?
Sure. So broadly, I think a lot of economists look at this in a similar framework as what Sean described. The idea is that there's a trade-off the companies look at when deciding on any settlement. Hey, I could win the patent litigation and make so much money. I could lose the patent litigation and make so much money or lose so much money. So I have an expected value under patent litigation. Well, would I expect my settlement to lead to more money? Am I better off under that settlement? In which case, we economists would often say, yes, it is rational to enter into that settlement. And then there's the question of, well, now there are these other considerations. What if there is a reverse payment? What if there is a particularly complicated structure to the settlement? How might that go and change the incentives? And so you might say, well, is a manufacturer made better off relative to the calculus under under litigation or a payment-free settlement? And so some economists have looked at that and said, okay, well, any payment is enough. And other economists have said, no, you need a large payment that's clearly enough to shift all their expectations that so as to lead to an anti-competitive result.
Right. I'm glad to hear that the general analytical framework is the same, but which all sounded very similar theoretically, but I guess in reality you have all kinds of difficulties. One of the difficulty is to actually assign the probability. Do you know, I guess the parties, they come in, they obviously biased, I'm going to win the case or not. They have some subjective assessment. How do you incorporate that, or are they going to, or do they actually have that kind of beliefs?
Yeah, I mean, I think you've got that exactly right, that this starts getting very messy. So one of the concepts that we look at here is this idea of subjective versus an objective probability. The idea that, fine, there is a true probability, but that might not be what the parties believe. And so each party might have biases, they might have their own beliefs. As I think Mark Gidley likes to say, you can add up the two parties' probabilities of that they each will win, and you might get a figure well north of 100%. So this actually makes it a little bit of a challenge. One of the parties might say, yes, I'm made better off as a result of this settlement based on my probabilities, but ex post, does this really change, move us beyond what the expected probability, a sort of objective probability here? And that starts getting really complicated. In addition, we as economists sometimes don't see their actual probability beliefs. That might be considered privileged if it was produced at all.
And I would just add on the when you're doing this for a client, the settlement analysis oftentimes includes a range of probabilities. So the client themselves has not always settled on a single probability for outcomes, but instead, like a lot of financial modeling, you are modeling scenarios, different ranges. So where within that range reflects the actual belief by the time of there's a lot of moving parts there that complicates this issue.
Right. But let's pick out one of the most important things, which is recoverable damages, right? Obviously, when we're talking about litigation, there are, especially in the pharma context, there are industry-specific remedies like exclusivities. But let's focus on recoverable damages. So how are damages calculated when it comes to the entry of a generic or biosimilar drug? I think we talked about at-risk launch a little bit earlier, but how is that calculated?
Well, there's I just note first that it's pretty rare for an at-risk launch to occur in the generic context. I mean, they certainly do occur, but it's very infrequent, and the vast majority of cases actually settle or are dismissed. In the biosimilar space, there's proportionally much more at-risk launches that have occurred. But regardless of what type of molecule we're talking about here, we're still talking about patent damages. So you're either going to get lost profits or reasonable royalties, and no less than a reasonable royalty. And it's really within probably the majority of those cases, we would tend to think that it would be lost profits that would be awarded, because these are two products that clearly are competing directly with each other. One is taking sales from the other. But I should note that it is not always the case that lost profits have been awarded in that context, because there can be other complexities involved. So there have been reasonable royalties awarded as well, although those reasonable royalties can actually be quite high. Unlike in some other industries, you tend to think in the tech space or what have you, of reasonable royalties being much lower. In the pharma space, a reasonable royalty rate can really be quite high.
Right.
So
Go ahead.
I want to drill down a little bit further into, this has been a very helpful conversation about the framework, about how to think about pharmaceutical settlements. But what is it about biosimilars that makes that discussion different than for, small molecule generics? What about the analysis is different for biosimilars, and why?
It's really the market dynamics that we're talking about that make this so different, or fairly different. One of the key questions when you're talking about lost profits is the extent of the lost sales that the brand has suffered as a result of the generic or the biosimilar being launched. And another potentially significant component of lost profits can be based on price erosion. So where the brand has to reduce or chose to reduce its price in order to compete with a generic or a biosimilar. Now, I said generic or biosimilar, but in fact, when we look at these marketplaces, what's clear is that in the small molecule space, the brand almost never reduces its price to try to compete with the generic. But in the large molecule marketplace, the brand typically does actually reduce its price after the biosimilars enter the market. And there's really a number of factors behind that in the marketplace.
Since we talked about price erosion a little bit, why don't we bring up that discussion a little bit earlier and focus on that here? So what is price erosion, and why is it somewhat different, I guess, gathered from what discussed, it's different, a little different from generic and biosimilars. How so? And maybe Archan, you can talk a little bit about that.
Sure. So in terms of the price erosion you might expect, it just goes back to this issue of very different dynamics. As Sean mentioned, we tend to see that that branded manufacturers, when it comes to generics, they don't tend to lower their prices. They don't tend to compete in that sort of way when you see generic entry. But biosimilar entry is just very different. We see that we see that biosimilars just don't get the same share uptake. So manufacturers tend to be a lot more branded manufacturers tend to be a lot more competitive here, and they sometimes will lower their prices. We've seen that when it comes to generic drugs, you can quickly see after a few generics enter that prices fall to less than 10% of the price of the original branded drug. When it comes to biologics and biosimilars, the biosimilar entrants, they result in a handful of percentage points of price reduction each. It's not. So far, we haven't seen that biosimilar entry has resulted in massive price decline. And as a result, those branded manufacturers the biologics manufacturers will tend to themselves, to some extent, lower their own prices, and so they have this possibility of getting price erosion damages in IP litigation.
I know there is a risk of oversimplification, but sounds like the market dynamics after the entry of generics and the entry of biosimilars are different. The degrees of price reductions for the branded drugs are different, and the new entrants don't get the same uptakes in terms of market shares. Is that right?
Yeah. I mean, I think that's right, that biosimilars don't get uptake the same way. And so biologic manufacturers will tend to reduce their own prices and stay in the game, if you want to call it that. Whereas with generic manufacturers, I've heard branded manufacturers say, "Oh, there's generic entry, we're out, we're done."
Right.
And they just, in some sense, are done with competing for share.
And some of that is how drugs get prescribed, right? So you go to the doctor, you get prescribed the branded drug, the branded small molecule drug. You go to the pharmacy, you get the generic. They can't do that with biologic and biosimilar drugs. And so there is more sort of competition in the marketplace directly with doctors for those types of drugs. I know neither of you are lawyers, but Archan, looking to you, how does that analysis, the fact that biosimilars differ from generics in that fashion, affect your thinking around whether a settlement is anti-competitive, if at all?
I think that's particularly tricky. I mean, part of the issue is, as you said, this automatic substitution aspect with generic drugs, whereas with biosimilars, the doctor has to affirmatively choose the product. And so, I mean, it can be an affirmative choice for the branded product, or an affirmative choice, hey, I'm willing to take this biosimilar. Sometimes we think of this in terms of consumer welfare, and whether consumer welfare is really enhanced by that entry. We might think of it in some sense as, do we see that aggregate volumes or spending, particularly volume, is it increasing after entry, or is it decreasing? Are people actually choosing to get this product more because, hey, they can get it cheaper and some of them will stay on their existing product? Or are we seeing a decrease because this promotion is dropping, and that non-price competition may well be dropping just because the branded manufacturers might not do that, particularly if there is automatic substitution?
Right. We talked about, so this is referred as the pharmacy level substitution sometimes, right? And then a lot of that is obviously controlled by state laws. But there is a concept of interchangeable biosimilars, right? Is that something? Is it more similar version of biosimilar, and somehow is that more, I guess, easier or more receptive to substitution?
So we've only seen one product that received an interchangeability designation from the FDA. And Sean, correct me if I've got this wrong, but the FDA basically requires a greater level of study to show to receive that interchangeability designation.
That's right. Significantly more clinical data is needed to establish that you can take a patient who's been receiving the branded drug and just move them over to the interchangeable biosimilar. So that's what we're really talking about when we say that you can just swap one out for the other.
Right.
And
go ahead.
Oh, sorry. And with the interchangeable biosimilar that has launched to date, we've seen that we've seen it launch. It's been about 6 months, and what we're hearing so far is that it's actually not received a ton of uptake. And what that is payers are not always choosing that product. We have actually seen that the manufacturer in question has an interchangeable version and a non-interchangeable version. And so they're doing some more complicated pricing than you would typically see.
Right. And then we were talking about uptake and also substitution. Obviously, we're just talking about a generic or a biosimilar capturing some market shares, I guess, that was once occupied by the branded. But how is that happening? Usually, how quickly can that happen in the market? And obviously, we cannot just assume away the laws that regulating the substitution but with all that in the background, how quickly a generic and biosimilar can capture shares?
That's very rapid for a generic. That's going to be maybe 70, 80% in the first month of volume is going to go from the brand over to the generic. And again, that goes back to the automatic substitution and formulary positions and some other factors as well. With biosimilars, it's much slower. But we don't have as much data on biosimilars. There's far fewer biosimilars that have ever been launched than there are far fewer than there are generics. So it could be that over time, this is going to accelerate more and more. I mean, if you looked at generics back in the 80s, shortly after Hatch-Waxman, whenever that occurred, my understanding is it was a much slower process over time. And so maybe what we'll see is an acceleration in biosimilar uptake, but I'm not making any predictions. I'm just saying perhaps we'll see this.
Right. And I think it's interesting that even with the bioequivalent, you didn't see that immediate, share takeaway, which is, I know it's one event, and we need to see many more before we can identify any trends, but something to look to in the coming years. Before we pivot to sort of the more personal questions of our segment, I know you don't want to make any predictions, but any thoughts on future biosimilar IP litigation settlements, things that you think practitioners or parties should be thinking about as they think about biosimilar settlements?
Archan, do you want to take a first shot at the tricky what's coming next question, or should I?
Sure. So, of course, I wouldn't expect to see cash payments or no AG clauses. We've seen the antitrust litigation around those, and some manufacturers have explicitly agreed to not engage in some of those settlements. One of the aspects that we might see is perhaps more accelerated entry clauses. The idea is if you are at least as well off as, or in a similar position as under Hatch-Waxman and under litigation, maybe there's an opportunity to see more clauses that would allow for returning to that status quo. But we've also started seeing antitrust litigation around those issues.
And to that, I would just add, and Archan mentioned AG, sort of the authorized generic concept. So another possibility, and again, just a possibility, is that you could see authorized biosimilar deals. Now, how those would fare under sort of antitrust scrutiny, I don't know, but manufacturing biosimilars is much more difficult than manufacturing small molecule drugs. And there can be know-how involved. There can be a variety of sort of tricky aspects for the biosimilar manufacturer. So if they can receive that information from the brand under a settlement deal, that could potentially be pretty appealing. Not necessarily something. Well, I guess either way, I have no comment on whether or not that would fare well with from an antitrust perspective. but just from a practical perspective, you could see something like that being useful to the biosimilar.
Right, or even something. Well, maybe not, but something you could see outside of IP litigation. You could see parties entering into commercial arrangements of that nature. Anyways, very interesting conversation. A lot to see. Biosimilars are relatively new to the IP litigation scene. So I think there's a lot to happen in the next decade or so. Before we let you go, Sean and Archan, we do have a few other questions to ask you. I guess starting with Sean, can you tell us something about yourself that those that work with you would not know?
Sure. Something about myself. During actually the start of the pandemic, I took up fishing. I live in Chicago, but I've had left town for a while during the pandemic and was working remotely up from Minnesota. I grew up in New York City. I don't know anything about anything about being outside and fishing or anything like that. But now I've developed at least a moderate amount of ability there.
That's great. Archan, did you know that? Did you know that about Sean? There you go. Okay, Sean, Archan, your turn to surprise Sean with information that he does not know about you.
So when I was in college, I did a year of study abroad and decided to take photography as an elective. Started becoming, doing photojournalism, and it just happened to be the year that Jean-Marie Le Pen came in. He went forward in the French presidential elections to the second round. And so I covered the protests. Well, it just happened that the French riot police had to save me as I was being ganged up on by a bunch of people who were angry that I took photos.
Wow. Sean, I bet you did not know that.
And that is a much better story than I learned.
Well, unless your fishing target is flying Asian carps, that involves a fair amount of force and violence there too.
And specifically for folks who want to be, I guess, consulting economists. Both Sean and Archan, you guys sort of have your own specialty, within that field. Do you have advice for young economists, kind of both looking to get into the consulting world, but also sort of to carve out or build out their own expertise within that area? Archan, let's start with you this time.
So I would say dig deep. In any area, there are a lot of special nuances to industries, to particular areas of analysis, and I think this specialization is incredibly important here, where you dig into how the industry really works and talk to folks in the industry and sort of build out that expertise, particularly for something like life sciences or healthcare, where the niches of the industry are particularly important.
Yeah, and from my perspective, for whether folks are interested in working as economic consultants or really a variety of different careers, is try a lot of different stuff. At least for me, I kind of happened my way into my current career. I used to be a scientist, and then I moved into patent licensing. And it wasn't really until much later that I got into finance and economics. So, and it's a good career path for me. I mean, I couldn't have planned it out that way, but just the experience that I got became useful in my current work. And so I think trying a lot of different things is sort of the key advice that I would give.
Great. And so now our final segment, what we call the Curious Hat.
And now it's time for the Curious Hat.
So Sean, can you pick a number 1 through 10?
Sure. 9.
9. Okay. So if you could choose free front row tickets for any performing arts show or festival in the world, what would you choose?
That's tricky. And this is maybe a little lame because I live in Chicago and this is where the concert is, but I've literally never been, is Lollapalooza. And I would probably take my 2 older children who are perhaps maybe not quite old enough, but they really are excited to go. We'd go to some daytime shows and, make it a family event, I think.
You got to get on that. It's in Chicago.
That's right.
I got to tell you, I've been there once. I don't think it's suitable for 7, 8 years old.
Good to know.
It's definitely going to be fun for adults.
And Archan, you can pick any number other than 9.
Pi.
Between 3 and 4. Maybe you'll have to answer 2. I'll round down to 3. Tell us about a time that you gambled on something and won.
I remember gambling on the Israeli elections many years ago, and a trifecta, in fact, and of course, the polling was right, the sentiment on the ground was right, and I won enough money to buy tickets to fly and go see my now wife, girlfriend at the time, in Paris.
Well, I guess, can attribute your hopefully happy marriage to a gamble on Israel. So anyway, Sean and Archan, thank you for your time today. And to our listeners, thanks for listening to this episode of Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.